What happens now if this does get kicked up all the way to the United States Supreme Court? Fox News legal analyst Mercedes Colwin. We've also got trial attorney Eric Weitz. What happens now, Mercedes, if you had to take a hunch what the Supreme Court does if it's handed this?
Well, the biggest vulnerability of this decision is the fact that the judge pretty much set aside the doctrine of severability. If you have a provision within the law, which obviously everyone says that the penalty was unconstitutional, then you remove that part of the law. You remove it, you don't apply it, and it proceeds with the law intact except for the offending provision. So right now, a lot of what's happened in the past with SCOTUS, when there is a cert, obviously you have to request permission to appear before the SCOTUS, before the Supreme Court. And they'll probably say to themselves, so there's already been a change in the laws of 2017 where the penalty was reduced to zero. So you don't have a penalty, therefore you don't have a taxation. Therefore, this whole issue as to whether or not it was unconstitutional as set forth in the 2012 ruling by Justice Roberts that said, well, it's constitutional because there's this taxation and Congress has these broad powers and therefore it can proceed. Well, you don't have that anymore. You have that provision that's been removed as of 2017. Now you have the judge that said, well, this individual mandate, this penalty still makes it unconstitutional. I'm going to toss it out. Severability set aside. SCOTUS now has the opportunity, and if you look at what they've done in the past, whether or not to grant permission to have these cases heard before the court, they look to see if there's been some change in the law that now changes the application to a particular case. So it's ripe for SCOTUS to step forward and say, well, the landscape of the law's changed. We want to take a second look at this case.
All right. So, Eric, in the event that they do and say that it's valid what the judge did, it effectively means millions who've gotten insurance under the Affordable Care Act technically could see that insurance go, right?
They could, but it's not completely ripe yet because Sunday the judge issued another order in which he scheduled that the parties were to confer and come up with a schedule or a calendar by the end of this week on how they're going to deal with some of the remaining issues. One of the remaining issues that the judge asked the parties to address that the judge deferred in this opinion is an injunction. This judge is not bashful. This judge has already in the past issued injunctions against the Obama-era transgender opinions. This judge has issued injunctions against parity for medical leave benefits for gay couples. So I don't know that it's ripe yet, but this confusion could occur much earlier depending upon how the judge handles that issue.
Mercedes, what does happen to those millions who have the insurance right now? I've always argued that Republicans should just hold back a little bit in their glee because the onus then is on them, right?
Oh, absolutely. And sure, look, as an employer, we have thousands of employees at our firm. We have to look at health care. It's such a significant issue, and most Americans need it. They stay at jobs that they stay at. They leave jobs because the health benefits aren't sufficient. So it is such a critical issue to so many, whether you're an employee, whether you're an employer, it's such a critical issue. And frankly, that we're looking for a solution. So as employers, we look for solutions to retain the talent that we need. Right now, it's going to be status quo. There are going to be controls in place to ensure that the application of the judge's ruling doesn't actually apply yet because there are going to be appeals. So it's a 30-day window for these cases to be appealed. There might even be motions for reconsideration where the party that lost step forward and say, well, we need you to reconsider your ruling. So we're talking months, years down the line where this actually will be resolved in one way or the other.
You know, Eric, when I talk to most people about this subject, they don't get in the weeds and they don't know certainly as much as you folks do about the legal implications. They are concerned about coverage for pre-existing conditions because most Americans can relate to that, fear for that, and wonder about this decision leading to the end of that. What is the legal message here on that?
Sure. This might be a bit of be careful what you wish for. Because remember, the name of the act is the Patient Protection and Affordable Care Act. The judge threw out a whole wealth of things, including subsidies to the Medicaids in the states for pharmaceutical coverage, other subsidies, coverage until 26, pre-existing conditions. Now, as Mercedes pointed out, that doesn't take effect right now, and presuming an injunction isn't put in place, that won't take effect now. But the interesting thing is, before the judge issued this ruling, all of these plans already took into consideration the pre-existing condition requirement that those be covered. And that's already built into the premium structure. And very interestingly, when the mandate was presumed to go away because this penalty went away, plans started to raise their premiums because healthy people were coming out. So the market has already factored this in. The market has found a level, apparently, where they're comfortable with pre-existing conditions. But it is a mess. But as Mercedes pointed out, most likely it could be years until that final issue is resolved unless Congress steps in before then.
Yeah, we shall see on that front. Guys, thank you both very, very much. I do appreciate it.